is my honor to welcome you here. Our elder has been delayed and she's not able to be here, so we will begin without that. You will hear first from President Roseanne Runty.
Good afternoon, everyone, and welcome to this session. On ordinary days, when we start a session, I am supposed to say welcome to the traditionally held Algonquin lands. And every time and today I'm going to admit something to you. Every time I say that, I feel like I shouldn't welcome you to the traditionally held Algonquin lands. They're welcoming us and me too. So I would like to say thank you to the Algonquins for letting us use this land and letting us feel welcome. Second thing I would like to do is to say that there are days that are special and there are days that are even more special. And Justice Berger is a very special person in the history of Canada. And he's sharing his special day today. It's his birthday. Can we applaud him? The third thing is that at this university, we have talked so much about our commitment to helping solve problems, real problems in the world. And we solve them by bringing people from different disciplines together and starting off with a discussion, starting off with a study of history, starting off with facts. And I would like to thank our faculty and staff for organizing this event, and I thank every single one of you for being here, because this is an important discussion, an important subject for the country, and this is the role of a university, to bring this discussion forward. So thank you for participating in it. Thank you, faculty, especially Frances Abel, for organizing this. I am deeply appreciative. And all the members of the panel, thank you for taking time in your very busy schedules to be here and share with us today. And finally, I would just say a little personal word. I have had, on a number of occasions, the opportunity to kayak and paddle across many kilometers in the north. And I have, every time I've met the inhabitants, they talk about the land as if it's got a capital L. And you can hear it in the way they talk about the land, their reverence for the land, and the way the land identifies them as a people. I go abroad to speak, and people say, what's special about Canada? And I always say it's the people, the wonderful people who volunteer, who care about each other, who come together and work to make it a better country. And they always say, yeah, but what about the cold? Isn't that special? And I say, yes, that's pretty special. And I get brought back to the land, because the land is special. And how we identify ourselves and define ourselves, even if we live along the southern border of Canada, is by being north. We are north of a lot of people in other lands. And together we share a love and a responsibility for the north, which is part of our definition as a Canadian people. So thank you for caring about this important discussion and participating in it. And join me in thanking our panelists.
Thank you, President Runty. There is a short video that our panelists would like you to watch before they begin speaking.
Canada, and perhaps even the world, should know about an event fast approaching. The Peel Watershed court case will not go unnoticed, and it will define us as a country. This region is roughly the size of Ireland or Nova Scotia. It's a place of beauty where rivers snake through the embrace of mountains that stand against the sky with an ancient purpose. It is a testament to the strength and beauty of our natural environment. The Hwech'in, the Hwech'in, the Trondek Hwech'in, and the Untitled have depended on these lands for their animals, their plants, and their crystal clear waters for millennia. The Yukon government hungered to open these lands up to development, while First Nations wanted it protected. A land use planning process spanning 7 years offered a compromise: 80% protection, while 20% for tiered development. Unfortunately, the government sought to turn this on its head, leaving 71% for development and a mere 29% protected. Legal proceedings were initiated against the Yukon government, and 2 courts found that they had acted in dishonor, failing to uphold the integrity of the Crown. Despite this, the courts granted them an opportunity to restart this process, putting the future of the Peel Watershed back at risk. In response, First Nations and conservation organizations are appealing this decision in front of the Supreme Court of Canada. What prevails will be the final chapter in a long, winding narrative of the conflict between First Nations, the Yukon Territory, the Crown, and the very country that First Nations co-founded, Canada. Although it is people that pretend to own these life-giving lands, it has served us longer than any patriot, and now calls for our service in return. We can come out of this unified, to prove that we are a nation of respect and foresight, and not one of blind consumption. And not just for us today, but for all of our generations tomorrow.
So the theme of this panel is protecting the Peel Watershed, Indigenous rights, conservation, and the law. We're here at an historic moment. Yesterday, Tom Berger made final arguments before the Supreme Court of Canada on the Peel Watershed case that's been brought by the panelists you will hear speaking about it today. We are 40 years since the release of the final report of the Berger inquiry into the construction of a pipeline in the Mackenzie Valley. Many people identify that report and the process that led to the findings, the Justice Berger's findings. Many people identify that as a turning point in Indigenous Canada relations in the North and in the development of the Indigenous movement in Canada. So it's an honor to have all of them here to speak to us, to talk about similarities and differences between the changes, the period of change over the last 40 years. It's also an honor to have all of you here. Thank you very much for joining us. And thank you especially to the number of visitors we have from the Hwech'in territory. It's an honor to have you here as well. First speaker will be Thomas Berger, who's the legal counsel for the case that you're going to hear about.
Well, thank you. You may wonder if this is a case of mistaken identity. You were told that today is my birthday, and yet in the hallway around the corner you have my photograph taken when I led the inquiry into the Mackenzie Valley pipeline 40 years ago, and I took a second look at it myself, and I thought, that fellow looks all right. Anyway, I think it is fair to say that the cooperation that began between First Nations and the conservation movement back at the time of the Mackenzie Valley inquiry was perhaps something new at that time, but it certainly has gathered strength today, and I am involved in the case to protect the Peel watershed, indeed to save the Peel watershed, because the folks in Canadian Parks and Wilderness Society and the Yukon Conservation Society back in 2009 came to see me in Vancouver. I wasn't exactly retired, but I wasn't trying to keep awfully busy, and asked me to become involved in the case, and so it has brought us to the Supreme Court of Canada yesterday, and we will no doubt have the judgment of the Supreme Court in a few months. I spoke at the Saw Gallery last night and reminded everybody there that these struggles don't really have an end point. It's not as if the time is ever reached where you can say, well, we won that one, now we can all just go back to sleep again and it'll take care of itself. It never does. There are always protests, there are lawsuits, there are crucial moments that are reached and struggles to be fought. Well, let me just tell you a little bit about the Peel watershed case from a legal point of view. When the First Nations of the Yukon settled their land claims back in 1993, they settled with Canada and with the Yukon. And they signed an agreement called the Umbrella Final Agreement, which, among other things, provided that they would be engaged in joint management of not only their own land, which under the Umbrella Final Agreement comes to less than 10% of the land in the Yukon, but that they would be managers, together with the government of the Yukon, of the public lands. And that promise made then is the promise that we seek to redeem today. The process established under the Umbrella Final Agreement 33 years ago was a collaborative process that I think is perhaps unique in Canada, but it's something that we are determined to vindicate in this lawsuit. But it provides that in every region of the Yukon, and there are 8 regions in the Yukon, and the first region in the Northern Department plan was worked out without controversy, but the second is the Peel, an area as large as New Brunswick and northeastern Yukon. And under the process established for land use planning, under the Umbrella Final Agreement, it's a constitutional instrument. The rights the First Nations have under the Umbrella Final Agreement are embedded in the Constitution. An independent commission is established to bring in a recommended land use plan. And in this case, the commission consisted of 6 people. It was jointly established by the Yukon and the First Nations. And it unanimously recommended, after 5 years' study, that 80% of the Peel be preserved, given a high degree of protection to preserve its wilderness values, that 20% be set aside for future resource and mineral and development. And it was a unanimous report. The way the process works, at that point, Yukon was to consult with the First Nations about what was to be done with the report, and it was to consult with Yukoners generally, with all the affected communities. It took in the whole of the people in the affected communities in that area. And because not only the First Nations of the Yukon were involved, the Hwech'in, who actually live in the adjacent area of the Northwest Territories, they were given a role in this process, and 4 communities in the Northwest Territories were treated as affected. So all of these people participated in this this exercise, territorial exercise. Now I should tell you that the peel is regarded not only in Canada but in North America as a natural treasure. The Commission received 10,000 submissions, 2,000 from Yukoners and another 8,000 from people in the US and Canada and around the world. So what happened then was this. The Yukon said, after studying it for a year, the Yukon government said essentially, well, this is all right with us. We agree with the 80-20 division. And their lawyer said yesterday in the Supreme Court of Canada that they misread the umbrella final agreement when they said that. But so they were obliged to send in their proposed changes to the Commission, and they were some technical changes, quite important, and the Commission agreed with them. And then there was to be a final consultation with the affected communities, and then the exercise would be wrapped up. But after stalling for a year, the Yukon in 2012 said, you know what, we are going to bring in a plan of our own. And they developed a plan of their own, providing for a division, 70% industrial, 30% protected land. So the First Nations and the environmental groups sued. And they said, well, wait a minute, you have to respect the process. That's why it's there. You signed the umbrella final agreement, and then you signed off on the independent commission. And then when you had an opportunity extending over more than a year to tell us whether you objected to the 80-20 division, you had no objections at all. Now another year has passed, and we are ready to move on to final consultation, and suddenly you announce, well, you made a mistake. It was all, it was a mistake on your part, but, and so now you want a do-over. Now we went to court in the Yukon, in the Supreme Court of the Yukon, and Justice Vail of the Supreme Court said to the Yukon, well, you can't do that. You agreed to this, you subscribed to it, you went along with it. You can't now turn around and try to get a do-over. And he said all that remains is to consult on those 3 technical modifications, carry out those consultations in the affected communities, and then you have to ratify the plan. And the only changes you can make will be based on those changes, those 3 technical changes you proposed in the first instance. The Yukon appealed to the Yukon Court of Appeal, and they agreed with Justice Vail that Yukon had breached the agreement. They had failed to act in conformity with the honor of the Crown. They had acted in a way that meant their own plan was unlawful, and they agreed with Judge Vail it had to be quashed. But the Court of Appeal then said, we're going to allow you to go back to the beginning. We think that's the best thing to do. Let's start over again and pretend that you've just received the report, the recommended plan, and you will have an opportunity now to put forward the vast changes that now appear in this new plan of yours. You'll have an opportunity to go back and propose your 30-20 division. Now, we went to the Supreme Court and argued the case yesterday and said, look, the Court of Appeal, we're very respectful of the Court of Appeal, but we think they got it wrong, that if you respect the process, if you agree to proceed in a certain way, if you have every opportunity to express your objection to the 80-20 division, and you don't do it, and lead everybody to believe that we are now on a course to finalize the plan on that basis, you can't come back and do it over again. You know, the moving finger writes and having writ moves on. Nor all your piety nor wit can lure it back to cancel half a line. Nor all your tears wash out a word of it. I remember those. But that was the whole point we made, that the process has to be respected and that Yukon is bound by its earlier course of conduct. So we are awaiting the judgment, and I'm simply introducing the subject so that you can hear from the other panelists who know more about the appeal than I do. And I just want to say that I have been very pleased to represent the First Nations and the environmental groups in the Yukon, and Yukoners generally, who very much favor the protection of the appeal. So thanks very much, and I hope that I've given you a bit of an overview from a legal point of view.
Thank you. Do you want the podium? It's my honor now to introduce Chief Roberta Joseph from Trondek, Hwech'in.
Drin Hozo, elders, friends, faculty, and students. It's a great honor to be in the traditional territory of the Kitigan, Zibi, Band, and Algonquin traditional territory. Masicho for the kind welcome, as well Masicho to the President for welcoming us here as well. I'm Roberta Joseph, Chief of the Trondek Hwech'in in Dawson City, Yukon. It's the northern part of the Yukon, and it's very close to the Alaska border. Just to give an idea of where my First Nation is. In my area, there's a lot of mining in that area, and in 1896, there was a gold rush that brought an influx of Europeans to the area, and that lasted a very long time. Today, there's a lot of placer mining going on in my traditional territory. Just to provide you with an example of the mining that's going on in Trondek Hwech'in traditional territory, 85% of the placer royalty sharing that the government receives comes out of TH traditional territory compared to the whole Yukon. The other 15% is shared, those royalty sharing are received out of the other traditional territories in the Yukon. So that's just an example of the amount of level of activity that we have to deal with in our traditional territory. So out of those, the 85% royalties, there are over 50,000 quartz claims and over 17,000 placer claims in my traditional territory. And every day that number grows. And it's going to continue to grow. So when we were dealing with the land use planning for the Peel, and it became apparent that the Yukon government lost sight of their obligations to the process in our final agreement. It was necessary for our First Nations who are affiliated with the Peel region to partner with CPAWS and Yukon Conservation Society to bring some regional and national recognition to this issue, and to prepare ourselves for court. The most important matter in regards to this, the Peel land use planning, is to ensure that we protect the Chapter 11 of our final agreement, or protecting our agreement. It took us over 30 years to negotiate our modern day treaty agreement. And because it took us over 30 years, we need to ensure that we protect it and ensure that governments honor the spirit and intent of our agreements. And so it led us on quite a journey through the legal process, as Mr. Berger mentioned. So it's been a long journey going through this legal process, and after having our day in court yesterday at the Supreme level, it makes us really happy to sort of seeing the light at the end of the tunnel of this matter. And all of our people, our communities, are now looking forward to the outcome, and we're hoping that we have a good outcome. The area, the significance of the Peel region to us is where we go to use the land. We harvest our food from the land. We harvest caribou and moose and small game and plants for medicine. We go and get water in the Dempster region. This area, this is a unique and beautiful region. One of the pristine, the most pristine places in Canada, and there's practically no industry in the area. When Yukon government started developing, working on the plan, there was a number of applications for mining that went into the area, and this area also has oil and gas values, and so they have a great interest to try and have a large value of industry in the area. And because this land has great significance to us for all that it provides to us, we have to protect it for our future generations. It's not for us today. We know how sensitive Mother Earth has become, and this is one of the areas in our part of the country, and even in Canada, where there are many rivers that are pristine and clear, that you can just drink water right out of the river. And it provides a wealth of food for our people. So that's how important this area of our traditional territory is to us. When I first heard, when this issue first came about, and Tom Berger was appointed as our legal provider, I was very excited about it and to be hearing his name. And I was thinking, I know his name, I know he was here before, and it brought me back to memories of when I was very young. I was about a teenager when he was going through our traditional territory, doing the Berger Inquirer, and I went and spoke there, and I talked about land claims, and I talked about that we don't need a pipeline in our traditional territory, and a few years back when the Peel case arose, I was given a newspaper clipping of what I spoke about at the Inquirer, and I was very surprised about it. And so when I read it sometimes, something written by a 13-year-old girl is really, really funny. But that's how I remember my first encounter with Mr. Berger. It was a great honor to be able to work with Mr. Berger on this file, and our First Nations who worked with him in this case really appreciate all that him and his team carried out for us. Just as I mentioned earlier, we've come a long way in this journey, and as well, we've traveled a very far, long ways to come here. We have a large delegation of about maybe 35 Yukoners, mainly made up of our First Nations, Trondek, Hwech'in, Macdonald, and Untitled, as well as Hwech'in, Hwech'in people and Hwech'in Tribal Council from the Northwest Territories in the northern part of our region. What's really important here as well, as I mentioned earlier, is to be able to fight, to protect our agreements. There's a process and there was a promise made by the governments, in regards to our agreements. Mr. Berger talked about that we gave up a lot for our agreements and for our land. We gave up a lot in our traditional territory just to be able to have that collaboration management. It was important to our past leaders, many who are not with us anymore, that we look after the land for 7 generations to come. And everything that we do is not for us today. We're always thinking ahead about our generations to come. And we've always been told by one generation after another that there will be a time when great hardship will be in the world. And we're starting to see the damage to Mother Earth and the veins of Mother Earth being destroyed. And that vein is, we heard yesterday, is the water. It's like the blood of Mother Earth. And we know that one day, that because of all the watersheds in the Peel region, that water will be able to use that water when there is water that is not usable in the future. During the land claims process, as I mentioned, we relied on the promise to ensure that our cultural and natural values that we have defined in our nation would be there for millennia, and being able to have a legacy, a good legacy, a positive legacy from our agreements to pass on to our future generations is what we've always been told that we need to do. And we're really grateful for all of the support that we did receive throughout the Yukon and across Canada and throughout the world. There's just to explain how beautiful our part of the world is. I was driving back home one day from a meeting in Whitehorse, and it was raining for about 3 days, and there was really heavy rain. And I saw these 2 guys. I was just outside of Whitehorse, and I saw these 2 guys that I didn't recognize, and they were hitchhiking. I hesitated to pick them up, and I decided that I would because it was raining so hard. And they were 2 Korean tourists to the Yukon. And so I asked them where they were going, and they said Dawson. So I said, well, I'm going that way. So I gave them a ride. And they were really like country. They looked, the way they were dressed, they looked like they came from the country in Korea. And they were dressed in their normal traditional clothing. So as we went along, I'm like, why are you going to Dawson? And they said, well, we were at the airport and there was a visitor, a tourist there, and we met him and we asked him, where would you recommend to go? And he said, Tombstone. And Tombstone is just outside of the Peel region. And I said, he said, Tombstone. And they're like, yeah, so we want to go to Tombstone. So as we got to Dawson, I said, do you know anything about our First Nation? So I explained everything, told them the whole story. And so we got to the closer to Dawson, and there's this hill, and it's called Tintina Trench, and you can see the Dempster Tombstone Mountain Range. So we're driving along, and and I pointed over and I said, over there is Tombstone, and they're sitting there and telling each other, Tombstone, Tombstone. So we get to Dawson, and the next day they hitchhiked up to Tombstone, and I went to have dinner with my sister and her husband, and he came in and he's like, oh, we picked up a couple of hitchhikers on the Dempster. and he said Chase, their grandson, was really entertaining with them, asked them a lot of questions and bothered them. So I said, who are they? And he's like, these two Koreans. So just to give you an example of how beautiful this part of our country is and how much it has to offer us, and how other people view it and value it as well. So we're looking forward to the decision of the Peel court case, and we hope that there's a positive outcome. And one of the most important things, as well as our court case and protecting our agreements, is the changes in climate change and how that is really affecting our ecosystem in the north. There are significant changes in global warming in our part of the country. The Yukon is turning hotter than anywhere else in the world, hotter, faster than anywhere else in the world. Our permafrost is melting, and it's affecting the wildlife, the plants, and our whole ecosystem. It's making it difficult for us to be able to continue harvesting our traditional foods. There are migration patterns that are changing for the caribou that we rely on, and there's a declining Chinook salmon population, significant decline that's been happening over the last 18 years, and we volunteer not to harvest Chinook salmon anymore. And there's another caribou herd that we share with Alaska, and we volunteer not to harvest that herd. So looking after some parts of our areas that have great value, we really want to ensure that, that we're still able to use some of the traditional foods that come from the land, because it feeds our spirit. When we go out onto the land, it feeds our spirit. One of our elders said, it's like our university. We go out there, we learn, we eat, we pick different plants and we use them for medicines, and we pick other different plants and we use those for food. And so being able to go out onto the land and feed our spirit as well as our physical and mental well-being is all a part of our identity that we really work so hard to restore and revitalize, because we've lost that for a long time. So having our agreements and the promises in the process, the collaboration process that's laid out in them, is a part of is a part of the reconciliation that needs to take place, and being able to implement our agreements is a whole nother matter. And we're starting to find ourselves implementing through litigation, and it's not something that we want to do. We want to be able to implement our agreements to ensure that we have a healthy community, be financially viable, and be self-governing and self-sustaining in our communities. So that's what we're focused on. And we've done a lot of work in that area for the last 20 years, and we'll continue to move forward in that direction together as a people, as a community, and as Yukon First Nations. We still have 7 more land use planning regions to do in the Yukon, and so this case will be precedent setting in the decisions on how those plans move forward as well. It'll be precedent setting in any other modern day treaties that have a land use plan in their treaty. So in closing, I'd like to thank everybody for coming out and listening today, and we hope that you will continue to support things like First Nations treaty, the honor of them, and Masicho Miigwech.
Thank you very much, Chief Joseph. I'd like to introduce now Christina Macdonald from the Yukon Conservation Society.
Good afternoon. Thank you for the introduction. My name, again, is Christina Macdonald. I'm the Executive Director of the Yukon Conservation Society. We're a grassroots environmental not-for-profit organization working in the Yukon Territory since 1968. It's a special opportunity for me to be here talking to you today for a couple reasons. One, my grandfather, Claude Bissell, was one of the early presidents of Carleton University from 1956 to 58. So it's nice to imagine him many years ago being up here addressing the students of the university. And two, Tom has touched many people, and Chief Joseph told the story about how when she was 13, she met him for the first time. And I recently learned that my father testified in the inquiry. He was a new professor of environmental studies at York University at the time, and I think he was brought into Ottawa to speak about energy. And at that time, he was arguing against oil and gas development in the Mackenzie Delta, arguing for energy conservation, renewable energy. And still to this day, that's an important argument that my organization is putting forward along with many people around the world. The Yukon Conservation Society is one of the 5 appellants that brought this case before the Supreme Court of Canada yesterday morning. We work very closely with CPAWS Yukon, which is the other conservation organization who appealed this case to the Supreme Court. Chris Ryder is here, the executive director of CPAWS Yukon, and he's been a huge player. His organization has played a huge role in getting us to where we are today as well. And I've seen a lot of CPAWS folks and YCS folks here, and it's been really great to meet you all. Nice to see some familiar faces out there. I started as the executive director when this case was brought before the Yukon Supreme Court in Whitehorse in 2014. So this has been a big part of my life now for 3 years. And when you're reading these factums over the course of 3 years, you start to fancy yourself a bit of an expert, a legal expert. So yesterday, when Tom was presenting his argument on our behalves and was getting grilled by the judges, and then Yukon government was presenting their argument, and then the interveners, I kept wanting to sort of pipe in and say, well, what about this? Or, you don't get it. But of course I didn't. But it was a very special and emotional moment. For me, a relative newcomer to the Peel watershed in this case, just 3 years, but to look around and see the courtroom there was full of people who have flown from across the country to bear witness. And it was a very emotional time and a special time. And wonderful to be part of something that so many people have worked together to make happen. So I live in Whitehorse, the capital city of Yukon, and I'm a newcomer. I've only been there for about 7.5 years. And I knew very little about the Yukon before I arrived. And Chief Joseph spoke to how Yukon is commonly known because of the gold rush and how 100,000 people poured in there to make their fortune. And that's pretty much all I knew about the Yukon before I ended up there. Gold and wilderness. And I think the mentality that the North is full of resources for the taking, where you go to get rich quick and then leave, is still with us today. In the Yukon, our territorial license plates feature a miner with his gold pan. The Peel Watershed court case that was heard by the Supreme Court of Canada yesterday is a direct challenge to that assumption that mining and other resource extractive industries like oil and gas drilling are the first and best uses of the land, and that it's free for the taking. I'd like to speak a little bit to the ecological value of the watershed. So the land use plan for the Peel watershed, the process considered the resource potential in the watershed, and there is resource potential. There are oil and gas deposits, and there are minerals like copper, gold, iron, zinc, uranium. But they also recognize the ecological and cultural values of the land. And they ultimately recommended, as some of the speakers have shared with today, and you saw in our film, that 80% of the region be protected with the remainder for development. The Peel watershed is a huge chunk of land, 68,000 square kilometers. So 80% of that area is many, many times the size of Canada's favorite parks. This is a land that supports species that are listed as national or international concern, including wolverine, grizzly bear, peregrine falcon. The porcupine caribou herd winters in the Peel watershed, and there was a COSEWIC report released recently, and this porcupine caribou herd is one of the few barren ground herds in Canada that are still relatively healthy. Most of the other herds are just plummeting. And so they winter in the Peel, and then they calve in Alaska in the Arctic National Wildlife Refuge. And Anwar is now being threatened yet again by oil and gas development. So we have healthy caribou in the Yukon, and I just speak from an ecological perspective, but how fortunate we are, and let's not take that for granted. The Peel watershed supports fish, it supports migratory waterfowl, and because it wasn't glaciated during, or much of it wasn't glaciating during the last glaciation period, it also supports plant species that are found nowhere else on the planet. The diversity of the species in the Peel is unusual for a region of these high latitudes. And the lack of glaciation that I mentioned and the wide range of elevations has resulted in these different habitat types. So you have mountains, and then you have these wide river valleys. And because of that diversity, it sustains this incredible diversity of life. So the size of the watershed and the diversity of the life it sustains are vital to our ability to be resilient to the impacts of climate change. The Peel watershed is the anchor, the northern anchor of something that's called the Yellowstone to Yukon Conservation Corridor. And that's 3,200 kilometers, starting at Yellowstone National Park and reaching all the way up to the Yukon. And I think that's something that's, for me, has been important to connect me to moving from beyond the Yukon to the larger conservation community and feeling connected to this international movement to protect wildlife, protect the environment on which we all depend. So the Peel Watershed court case also challenges the assumption that the land is free for the taking. As you've heard from the speakers already, land use planning in the territory flows from the final agreements, which are modern treaties that many of the Yukon First Nations have negotiated and signed with the federal government and Yukon government. And this tool isn't just for governments and Indigenous people, it's also for non-Indigenous people like myself. So I can have a say in how land in the Yukon is protected, developed, and managed. And that's been one of the most powerful things for me in the 7 years since I first moved to the Yukon and became immersed in this court case, because I had no idea before what these modern day treaties were about and what they guaranteed for all people in Canada. And so for me to be included in those treaties has been a very powerful thing to awaken to. And the Yukon is a very engaged territory. There are only 35,000 people in the entire territory, 26,000 people in Whitehorse. So when Tom talks about the thousands of people who have participated in the land use planning process for the Peel Watershed, we're talking a significant percentage of the territory's population. So many thousands of people have spoken out for the Peel Watershed over the years. The conservation movement that CPAW's initiated is 20 years in the making. And so it's really rallied the entire territory. We had an election in November, and the Peel Watershed was the second most important issue on people's minds after economic the economy of the territory. So when the Yukon government of the day tried to throw away the results of this land use planning process that so many thousands of people had participated in, we all rose up and we said, "How dare you? No way." And we took them to court. And here we are today. It's been 3 years of a lot of work, a lot of blood, sweat, and tears. And it's been an enormous honor for YCS, and I can speak for Chris Ryder for CPAW's Yukon, to be part of this process, making history, and to be working with Chief Joseph of the Trondek Hwech'in, Chief Mervyn of the Natchinayak Dun, and Chief Charlie of the Hwech'in, and to be allies and supporters in this very important work. And essentially what we're arguing is that Yukon government, this one and all future governments, doesn't get a do-over if they don't like the results of this land use planning process. And they can't participate in this process only at the last moment to throw it all away. So one, we've argued that that's not legal. And what we have here in Canada is far too precious for that. I think we've had a lot of do-overs, and I'm all for second chances, but this isn't a second chance. There have been a lot of chances, and what we're saying is no more. So a win at the Supreme Court of Canada will protect the Peel Watershed and the modern-day treaties we are rebuilding our nation on. And to conclude, I'd like to ask you for your support. It's going to be some months before the Supreme Court ruling is released, and so we're all going to be holding our breaths until then. But once it's released, in some ways, it's just the end of the legal process and the beginning of the next bend in the river to seek, this is a recommended plan that we're having upheld. And so then we have to, the Yukon First Nations working with the Yukon government, have to look at the Peel and decide what kind of permanent protection that area should receive. And that area will need to be monitored for the rest of time. So this is not the end. And one way that you can support us is by going to www.protectpeel.ca and signing the Peel Pledge. Please join with us and show your support for protecting this land. Thank you very much.
Thank you very much, Christina. We have one more speaker. We will be here until 4:30. So after Dana has finished, there'll be lots of time for questions and comments, and I will invite you to do that. There's some microphones in the middle aisle. But our last speaker is Dana Tisha Tram. He's from the Hwech'in First Nation, the most northerly First Nation, I believe. Do you want to speak here? Yeah. Dana, if you can do 5 minutes, that would be great.
My name is Dana Tisha Tram. I have a lot of names, and I also have a lot of titles. I am a part of a lot of organizations, president and co-founder of the Youth of the Peel Society, as well as our Voices, and I also happen to be on council with my First Nation. But I was asked to speak to you today as a young Indigenous person, and I will do that. I am very thankful for this opportunity to speak, and I'm very thankful for your open ears and your open mind and your open heart. And I will take this opportunity to earn that. You know, we have yet today to produce any technology that can mimic the efficiency or the longevity of the natural systems. This is why First Nations take the land as our ultimate teacher. It is because it is the ultimate technology. It is not some arbitrary ideology. It is the humble practice of putting yourself aside and recognizing where true power is. Because the moment that you don't is when it will destroy you. Ask any sailor that, or ask anyone who spends their time out on the land without a gun or without a lighter. It's the first lesson that you'll learn. But as a young Indigenous man, I will have to tell you as well, and out of respect for you, I will not stand in front of my own truth, which is my experience. My experience has not always been a good one, nor is any person's, but I still stand here today with hope and complete positivity. But I'll tell you that having to grow up, I had a lot of questions about a lot of things, especially within my own family. It wasn't until 12 years old that I went to a Thanksgiving meal where I realized that the plate I was holding in my hand was from residential school. That set me off on a completely different journey. And to this day, nobody in my family talks about it. When I say that I am Hwech'in, I say it proudly. That means the people of the lakes. Hwech'in simply means people. There are Hwech'in all across Canada, and there are Hwech'in here in this room today, because we are all people. But my people defined ourselves by the lands that we came from, the land of the many lakes. Hwech'in. We are the land. So for the Peel Watershed to land again in colonial hubris, in the breaking of the laws, their own, and the manipulation of them, to do this to the land, again, is likened very much and correlates directly to residential school. And I make that correlation not lightly. But I say it for a reason. And it's not to weigh your hearts down. It's to feed them. Because I believe that with the right information, people will make the right decisions. And maybe that's all we're missing here. But I also don't want to give my beautiful home my beautiful territory, and my country a black eye. Just because one bad apple can go and push us into this corner does not mean that's who we are. And I don't believe that. And that's why I stand aside and I show you my truth today. I believe that there will not be another residential school. I believe that. But I also hope that there will not be another Peel Watershed. So to share my truth with you today, I'm very happy to do so. And I thank you very much for opening your hearts and your ears. And I very much look forward to the discussion we will have today. Because for a young man who was told and taught by many other people that I would not amount to much, to be here today speaking at a university and to sit with such amazing people is absolute proof that our hearts are the most powerful thing, and hope will not only move mountains, but it can change the world. But we first have to have that hope. And so I ask you, the Peel Watershed is just a symbol, really. How much more of our land are we willing to trade off? Industry is real. The position we are is real, but also is the land. So I share this with you, and I hope that you will share our hopes with us as well. Masicho.
Thank you very much for everyone. Now is the time for conversation. So may I invite people to come to, there are 2 microphones in the middle aisle. I'm sure the panel would like to hear from you. And of course, I have a question ready in case you don't want to be first. Sorry, Dana, I'm having trouble focusing in the after listening to you. So and I don't have to go first, so please go ahead.
My name's Ben. I was lucky enough to move to the Yukon when this was first going in the court case, so I've been in the courts following it throughout all this process. So seeing it here today is it's a reassurance that I'm in the right program doing my master's. So I wanted to quickly thank the school for hosting this.
Ben, I think you need to speak a little louder.
Okay.
There we go.
That's
There
good.
we go. My question is broadly addressed to the whole panel. When I was listening yesterday to the Supreme Court, there was a lot of conversation about how do you deter governments from doing this over and over. And the Chief Justice was remarking, is the judiciary just going to become kind of a babysitter for this kind of land claims process over and over again? So my question is, if you think the land claims agreements should include some sort of paragraph or section that outlines what the repercussions are if the process is breached. It wouldn't replace the judiciary, but kind of act as an outline and kind of expedite the process. Do you think something like this is beneficial or not entirely?
Thank you very much. We're all wired, so who would like to start?
Well, maybe I could reply. The process to develop a land use plan for the Peel went along amicably between the Yukon government, the First Nations, and the public for many years, at least from 2004 to 2012. I mean, it wasn't as if they were at each other's throats, but what happened in 2012 was, as Justice Vale in the Yukon Supreme Court said, they took a sudden swerve away. He said they went out on a frolic of their own and devised their own plan, seeking to thwart all the work cooperatively that had taken place. And so it is this one, so far as the appeal is concerned, one very sudden and very substantial departure from the path of cooperation that has been condemned by the courts, and they use the expression the honor of the Crown, and they have both the Yukon and the Supreme Court of the Yukon and the Yukon Court of Appeal have said you didn't observe the honor of the Crown and that you breached the agreement. Now, the Chief Justice was asking I think the lawyer for the Yukon, as a matter of fact, and you put it very well, well, why are we babysitting this? I don't pretend to know what was altogether behind the question, but I think that we have to rely on the goodwill of the parties. There's a new government in the Yukon. Maybe it is more likely now that goodwill will be restored between the parties. There's no substitute for these folks working together. It's taken many years to persuade governments that First Nations are important players in land use and in government and in the allocation of land and resources. But sometimes there is backsliding. And when that happens, you go to court. If you had some agreement, some clause in the agreement that said what is to happen, when you have a disagreement, it might provide for arbitration. In certain instances under the umbrella final agreement, there can be arbitration. It didn't apply here. But these disputes are going to break out from time to time, and if one party or even both parties are intransigent, the courts are the only place where you can go to have a definitive answer. And that's unfortunate. It'd be better if they could work all this out for themselves. And with the new government in the Yukon, it seems to me the chances of that in due course are a lot better.
Thank you.
I would add, I mentioned this has been a long process, and it has captivated the territory for over a decade. And it's not the only court case that First Nations have brought against Yukon government. So I would like to think that after so long, people, industry, everyone is starting to wake up to the fact that the Yukon isn't a frontier anymore. It's full of people, and there are these final agreements that allow for things to proceed slowly in a way that in which all parties are consulted. The House of Commons was meant to argue, or was meant to review another controversial matter of the Yukon yesterday. Bill, I'm going to mess it up.
C-17.
Thank you. Bill C-17, which is a bill to repeal amendments made to Bill
S6.
S6. Chief Joseph was there. But unfortunately, the Conservatives pulled some tactics to prevent that discussion from being held. But that YESUB is Yukon's Yukon Environmental and Socioeconomic Assessment Board, and it was birthed out of the final agreements. And it is yet another way for all players, First Nation governments, Yukon government, and community members to have a say in how development projects take place in the territory. So I think that there is an awakening, and the appeal has certainly woken everyone to how expensive these things can be and how much they slow things down for everyone. This hasn't been good for anyone, industry included. And so I think we're starting to see some commentary from industry, and this is my perspective only, that they're beginning to recognize and respect these agreements.
I'll decide. So back to your question in regards to having collaboration rather than going to the court. As mentioned, there were many years of discussion on appeal development, and there was ample opportunity for Yukon government to submit their modifications, and so when the government, there is a clear process for consultation on the recommended plan, and there are clear processes for other matters that pertain to collaboration in the final agreements, in our modern day treaty agreements in the Yukon. So when there is a breach or going off the rails on these, it's not just something that happens overnight. We have long discussions, years of discussions on any matter before we resort to litigation, and it all depends on the government of the day as well. So we weren't working very well with the government of the day, and today we do have a new opportunity, a reset button to be working with a new elected government, and being able to working with the government, being able to have a good relationship with the government to move our agreements forward and move our discussions forward is great for our it's great for our environment, it's great for our economics, and so whatever takes place, whatever decisions happen, it doesn't only affect us, but it affects the Yukon, it affects the economy, and with this case and other matters as well, put a real black eye on the Yukon in terms of investment for economic opportunities and for a while, and now that is sort of turning around, and the government of the day is willing to sit down and collaborate with us to ensure that our agreements are followed, and are really putting a lot of pressure on all of the staff to ensure that's taken place, and we find that really respectful, and that just not very long ago we jointly met with many ministers here in Ottawa on many issues, and that was the first time we ever came here jointly. So developing a new process like that, First Nations working as government with the Yukon government as partners, bringing our joint initiatives forward together is going to provide a good example across this country on how First Nation governments and territorial or provincial governments can work together to advance the economy and their common interest together.
Thank you. Dana?
Yeah, and quickly to your question, which basically if there should be a provision within the land use planning process to deal with breaches, to me that's basically like saying there should be rules for, a fight if it breaks out at a spelling bee. It's the truth, because let's be honest here, we're not in the courts, we can speculate. The Yukon government walked across our agreements, they tried to step over First Nation backs to get to the land. They tried to get to the minerals, to the even possible uranium in that area. That's what they wanted. The land use planning process is clear-cut. I've been subject to a lot of committees and a lot of meetings conducted. I mean, Robert's rules. I mean, it's easy enough to follow. So our land use planning process should be clear enough. What's missing from the equation is respect, because First Nations wanted 100% protection. But you know what? We were willing, on the Independent Commission's assertion, we were willing to work with 20% tiered development. It's just too bad that the other side of the table couldn't pay the same respect to the process and to the integrity of the agreements. So, to answer your question, I don't think that we're going to need those provisions for a breach. What's going to come out of the Supreme Court case will ensure that the manipulation over their interpretation of consultation will be protected till the end of time. And the fact that it's in the Supreme Court shows that it's of national significance. It is an interest to all of us, all Canadians, that this be respected. It's just too bad that our Supreme Courts have to educate our public officials to what our agreements actually are.
Thank you. Chief
As
Justice?
well, I just wanted to also mention that we do have a dispute resolution in our agreements, but that it's not really effective. It will be effective if all parties agree to it, and so it's not something that we can use for something that's this significant. So, and it's been difficult to use that process for other matters. It just, one party doesn't want to come to the table, so it's not an effective process, and it's usually not us that doesn't want to come to the table. It's usually other parties. So thank you.
Thank you.
Thanks.
There is another question.
Thank you so much to all of the panelists for being here today. I think we're really grateful for your presence. Thank you so much. I'm Lisa Mills. I'm in the School of Public Policy and Administration. I'd like to ask you, Thomas Berger mentioned the swerve of the government in 2012. Why did the government swerve? What was it that pushed them at that point, having been fairly cooperative up until then?
Well, I think, let me just say that they say that they hadn't formulated their approach to questions of how much land should be protected and what access there should be by way of roads into the Peel and so on. And they said that it took them a couple of years to figure out exactly the balance between the protected land and the land available for resource development. And it took them really about 2 years following the announcement by the Independent Commission that they favored in their report an 80-20 division. And I'm sure the truth is they didn't have a position. They said, well, we're a little uneasy about this 80-20, but that's not enough. Judge Vail said it was a bald expression of opinion. We think there should be more land for resource development. But the commission in a 300-page report had divided the land up into 21 land management units. They had dealt with each of those units at length, set out the ecological resources, set out the potential, set out their rationale for saying, we think this particular area should be protected or this particular area should not. And when the Yukon government responded to the commission with 3 technical modifications, and then said, but we wish there was a better balance. The commission said, well, we can't deal with that. You've got to tell us where and why and give us reasons. And of course, the provisions of Chapter 11 that Chief Joseph referred to set out in detail that at the point when you want to modify the plan, you have to give written reasons. And the commission said, look, we gave you our reasons, 300 pages. All of you have given us is a sentence. And the courts said, well, that's not good enough. We hope that the Supreme Court will take the same view and direct that the process should go on to be concluded on the basis of the 3 technical proposals they made, which were perfectly reasonable, and that the opportunity to go back to the beginning and start over should be foreclosed. I mean, that's what they say happened. And their lawyer said yesterday, they said, well, we misread the umbrella final agreement. Well, we'll see what happens. That's their story, and they're standing by it.
Okay,
Christina? If I remember correctly, there was an election.
Yeah.
That's why the swerve happened, I think, too. So we had been asking the then premier of the time, leader of the Yukon party, come out, tell us your intentions for the Peel. And he refused. He refused. And then they were reelected. And then suddenly, out came the real plans for the Peel. So that's what happened too. Yeah.
Thank you. There is one more person waiting to ask a question. That might be our last question. Excuse me just a minute. Anything else the panel would like to say? No? Okay. Please go ahead.
Okay, I'm Roger Rickwood. I teach applied political ethics at the University of Ottawa, and many of my students have been very interested in these land use claims and the development projects. And this particular one is a bit more obscure than the rest of the ones. It hasn't got the publicity, perhaps nationally, that it should. And I would thank you, Justice Berger, for being involved, because where you go, the cameras follow. And that is tremendous. I've followed you for many years of my life, and I commend you for your continuing action. My question comes back to the old Roman phrase, cui bono, who benefits out of this? We've got a little territory there, 37,000 people, 26,000 live in Whitehorse, so the rest are outside. Who are the interests that are lurking behind the government to push this? Are they the national or multinational corporations? Little governments don't push things like this to the degree unless somebody is whistling sweet, nice words in their ears. I'm not asking you to break any confidentialities or that, but C. Wright Mills taught me years ago that first identify the forces that are in the power elite, as he called it back then, that are driving this. Because it just seems to be a great big mystery that in this obscure corner of our country, which is so beautiful from the pictures that I can see, that all these interests are suddenly sitting down and holding hands with the government. And one of the tactics that I've learned through my Saul Alinsky tactics over the years after going after interests, you've got to clearly identify who are the enemy and who are the people in between that will go either way. You can probably persuade them to do the right thing if they get the right information. So I don't know whether you can help me out or not, but I need some clarification, so perhaps I can do some targeting of my own.
Thank you very much. And I've noticed there is one more question after this one. We'll take your question. But panel, could you please answer this one, the one on the table, if you wish. Chief?
Well,
Yeah.
yeah, go ahead.
Sure. Well, it's kind of it's a good question. Thank you for that. And I think, there's been a lot of drive from the local industry, and there, like this, the government that was of the day was their main focus was the economy, and as well, they had a lot of help from the federal government, who is the same party at the time. Really, they were really focusing on industry, and there was not a lot of collaboration with First Nations. There was we actually had a lot of issues. Just as an example, in my traditional territory, as I mentioned to you, there's a lot of mining activity that's going on there, the largest out of all of the Yukon, and just with that, so there's a lot of drivers coming out of my traditional territory as well. In regards to that, there's other organizations in the Yukon. There's the Yukon Chamber of Mines. There's Yukon Mine Alliance Association, and Yukon Mine Alliance Association is made up of junior mining companies, and I don't think that they might not all have the same values. There are some of them who do have respect for First Nations and for our agreements and trying to do things the right way rather than trying to take the shortcut route. And and I think that there's been a lot of education. Like, people are starting to learn now. Industry is starting to learn that they want the new government today in the Yukon to be working with First Nations, because they've really taken a hit on investment and support. Investors do not want to invest in a region that is where there's poor relations with First Nations, and that's one of the things that the new government has really stepped up in terms of working with First Nations. And with that, there's now we have one of the top world gold companies in the world has invested into Trondek, traditional territory, which is Gold Corp. And that's really significant, and that's going to bring a lot of attention by other companies and other miners. So we really have to deal with these kind of things in terms of who's trying to drive the economy. But the new government, their priority is to have a diversified economy and not just be focusing on industry, but also be putting money elsewhere to increase other opportunities for Yukoners. I hope that provides somewhat of an answer.
Could I just add a footnote to that? We're here at a university, and so we're entitled to speculate a little bit about the deep-seated motives that drive people to a worldview. And I think people, certainly of my generation, were raised to believe that progress was represented by building dams and mines and extracting resources. I mean, that was our heritage. You don't remember all this, I guess, but when I grew up, that's the way we felt. I know when I went to the Northwest Territories to conduct the Mackenzie Valley Pipeline Inquiry in 1974, I had, as a lawyer, before I became a judge, represented the incipient environmental movement. It was small, and it was not always well regarded. I had represented First Nations in very early cases in which we sought to establish their Aboriginal title. But when I went north, the assumption was, and I suppose I shared it, well, they want to build a pipeline from Alaska across the northern Yukon, carrying gas from Alaska and then from the Mackenzie Delta along the Mackenzie River to Alberta. Was at the time the largest construction project, I think, and at least it's the largest agglomeration of capital behind a project. But it seems to me that people have deep-seated attitudes to the world, to the economy, to the environment, that aren't attributable only to economic drivers. That's what I'm trying to say. It's a whole congeries of things go into making up the attitudes we have. I think those attitudes are changing. The attitude toward First Nations has changed greatly. The attitude toward environmental values has changed. But I just don't think it's somebody in New York or Toronto picking up a phone and saying to the local politicos or wherever it may be, well, I want to tell you what we're going we want to do there. I mean, that's a big part of it, but forgive me, I don't pretend to know anything about this. Maybe we should all get into your course and discuss it, but
not now.
We
are at the end of our time. We have one more question.
I'd like
Dana, go ahead.
to quickly comment
Yeah,
on
please.
that, if I may. First of all, I really commend the question. It's, every question in and of itself is a little bit of an answer, as it gives a lot of perspective. But in the heyday of the Yukon Party government, if I remember correctly, 35% of the Yukon Territory's economy was hinged upon mining. And now I like to say that we stopped, that pretty much has come to a complete stop. And so now we don't mine minerals, we mine tourists' wallets. So please come and visit our beautiful, amazing country. But, at the end of the day, I'd kind of like to reiterate a little bit about what they had said, is that, I don't really think that they had a whole lot of backing, maybe perhaps internationally. There is Chinese interest in the Yukon, and they are there. But in any case, the real point is that during the commission, during all of this, industry was not present, which either meant that they weren't there or they had the ear of the government and didn't feel like they needed to be. But in any case, we do have a local presence, as Chief Roberta Joseph put out, but at the end of the day, only the Premier and their ministers will know that.
Thank you
for the question.
Thank you. One last question, and then I'll thank our guests.
My name is Noel Salmond. I teach in the humanities program here. The chief began by acknowledging our location on the traditional territory of the Kitigan-Zibi Anishinaabeg. And I was wondering whether Justice Berger could comment on the fact that yesterday you were in the Supreme Court, but the Kitigan-Zibi Anishinaabeg have, out of frustration, gone to court, I think at the end of last year in December, saying that, well, the islands around the Chaudière Falls, the land that the Supreme Court of Canada sits on, and the Parliament buildings are all unsurrendered, unceded Algonquin territory belonging ultimately to their community. So that's just a community 2.5 hours north of here. There's another Algonquin community, another hour past there, the community of Berger Lake, and in the early 90s, they entered an agreement with the Government of Canada and the Government of Quebec called the Trilateral Agreement, which was to manage the land around their community at Rapid Lake, which entails the La Vérendrye Wildlife Reserve. But again, there's been a lot of frustration because the federal government withdrew from that agreement, and Quebec has been waffling on it. So I'm wondering whether, Justice Berger, you could comment on the potential significance of these more local cases, the claim for the land that the Supreme Court itself sits on, and then this trilateral agreement, or I wonder whether you're familiar with that case.
No, I'm afraid I'm not. But I would leave, not exactly answering your question, but when I went to law school in the mid-50s, there were no courses on the rights of Indigenous people. As far as the law schools were concerned, they had no rights. They weren't taught. We who were students never raised the question, what about the folks who live among us, who were here for years before we came? What rights do they have? And it wasn't until the 1960s that cases went to, well, and really into the 70s, that the Supreme Court of Canada began to develop a whole jurisprudence relating to Indigenous people, Aboriginal rights, Aboriginal title, land claims agreements. And all of that is built up over the last, I hate to say it, I guess it's a half century, but it presents a much different landscape than it did when I started out. For instance, in those days, if somebody said, do you know that the Esquimalt people actually own the land where the BC legislature sits? People would say, well, you know, who cares? It's, you know, don't bother us with that stuff. Well, you can say quite seriously now, the Algonquins own the land where the Parliament buildings sit, and for all I know, they have a lawyer already looking into it. Well, the courts have been have played a real part in establishing the rights of Indigenous people. They all along believed they had these rights, but now the Supreme Court has articulated those rights. All I can say is we hope the process will continue in the case involving the Peel River.
Thank you, Noel. Thank you very much, everyone. I'm here to say thank you to Sheila Grantham, who's at the back, and to Mary Giles, to the library, who are the co-sponsors of this event with the Faculty of Public Affairs. Sorry, I got distracted by what I was listening to and I forgot to do my duty. So we're very grateful for their work.